Thank you, Diego. The second roundtable of Euro-Latam Lex speakers deals with 5G, privacy, and cybersecurity issues. Joining us by video is Elisa Figueredo, and I now call to the stage the Romanian Executive Director of the World Jurist Association, Teodora Toma, who will introduce the panelists for this next presentation. Thank you.
Can I speak? Good morning, everyone. Welcome to this panel on 5G, privacy, and cybersecurity. Although we don't have much time to introduce the topic, I would briefly like to mention the growing importance of this sector and topic, and the growing importance of 5G technology, which is virtually a reality now, to improve connectivity between all of us. But of course, with growing connectivity and growing business opportunities, also we need to increase the level of privacy and cybersecurity, and that's exactly what we're going to talk about. And that being said, I will now leave the floor to James Black for our opening remarks. Thank you.
Am I on? Oh, here we go. Antes de ofrecer mi breve presentación sobre el estado de las reglas de privacidad a nivel internacional, me gustaría dedicar un momento para agradecer a mis queridos amigos Javier, Diego, Teodora, Miguel, Gabriel y a todo el equipo aquí en Madrid por preparar y organizar esta increíble conferencia. Todos los días me siento muy agradecido y honrado de ser su colega y de trabajar con ellos en esta misión tan importante de la World Jurist Association y la World Law Federation, mientras defendemos la importancia del Estado de Derecho en todos los países y en todas las sociedades. And now on to the status of privacy in the world in 2021. We all can agree how important diversity and individualism is. That is true not only for us as people in many aspects of our lives, personally, professionally, and as members of societies, but is also true of cultures and societies themselves. Our world is richer and better because societies and governments handle things differently, and because people in those societies believe differently and act differently. However, we all know every rule has its exceptions. In my brief statements this morning, I'll try to make the point that privacy laws and regulations are an important and necessary exception to this rule of diversity. Privacy is a fundamental and basic right. It is so important in many of the countries represented in our conference that it's a right specifically protected in their constitutions. However, in many jurisdictions, privacy protection is often inconsistent and sometimes virtually non-existent. I propose this situation needs to change, and countries need to work together to create a global privacy standard. Let me now take a few minutes to review the status of privacy rights in various regions. The European Union continues to be a leader in the protection of personal privacy rights through the General Data Privacy Regulation, or the GDPR. Data privacy agencies, together with individuals, such as Professor Schrems and his NYOB organization, have brought actions against big tech, such as Facebook and Google, as well as other companies, service companies such as Marriott, for data privacy violations. These agencies and individuals continue to insist that data controllers and data processors comply with the overriding policy of privacy by design. They've forcefully rejected attempts by big tech and others to do the bare minimum and simply comply on paper with strict, narrow interpretations of the regulation, or it has been properly named non-compliance by design. While there was some concern of what privacy would look like in post-Brexit Britain, the UK Data Privacy Act of 2018 and the Data Protection and Privacy Electronics Communication Regulations of 2019 have effectively incorporated the EU's GDPR into English law. So the British remain strict enforcers of the data privacy rights. Moving along, the Asia-Pacific Cooperation on Privacy continues to enforce its so-called 9 principles of data protection. Now, while these protocols have weaker enforcement tools, with notable exceptions, most of the 21 member states continue to work toward expanding rights and protections of data privacy. The countries of Latin America stand out as beacons of data privacy rights. As I mentioned at the beginning of my remarks, many of this region's constitutions include the right of privacy as a fundamental right of its citizens. In addition, they've backed up these rights with statutes and regulations as well as enforcement actions. Our last stop on this little tour is, of course, the United States. While the U.S. has been recognized throughout its history as an innovation leader in many areas, privacy is sadly not one of them. There are very limited privacy laws such as Gramm-Leach-Bliley, which focuses on financial information, the Health Insurance Portability and Accountability Act, which focuses on health information, and Children's Online Protection, or COPPA, that focuses on protecting children while using the internet. A fundamental difference between the U.S. basis for data privacy and the basis elsewhere is that the U.S. focuses on the protection of types of data. The rest of the world looks at this as an underlying privacy rights of the individual. So you see, the United States is not only an outlier in protective regulations, but also, unfortunately, an underlying philosophy. Interestingly, a few of the more progressive states, notably California, New York, Massachusetts, and Virginia, have given up waiting for the federal government to act and have passed their own privacy statutes, often adopting the GDPR privacy principles as the basis for these statutes. However, many of us who practice in the privacy area continue to hope that the U.S. federal government will develop and enact a national rule that's compatible with privacy principles adopted by the rest of the world. We know that 50 separate state solutions are not and cannot be the way to protect the privacy of U.S. citizens. So in conclusion, as diligent advocates of the rule of law, we cannot stay silent about the vast disconnect among countries on the fundamental human right of privacy. I look forward to our conversation this morning, and I hope we'll be able to discuss ways to bridge these gaps and have a more unified global approach to the fundamental human right of privacy. Thank you. Thank you.
Thank you, James. Thank you, James. Our panelists today are all lawyers from different countries, but we're very honored and proud to have included the CEO of a very important technological company like Stefanini, who is Farley Kothe. So, Farley, you have the floor.
I'm so glad to be here, bringing some IT flavors to your legal event, because it is a strong match. I'm representing here one company that is present in most of the countries that you are, more than 40 countries, and we are 27,000 people supporting companies, organizations, and government institutions like you are supporting as well, okay? About the cybersecurity challenge that we are facing, and I'm talking about everybody, not just companies or governments, institutions, private, public companies, and as individuals, we are really facing by far the tougher period about cybersecurity. Why? Because that's purely based on data. And nowadays, with all this technological stuff that you have around, it's so easy. We are, in a way, helping the hackers to do their jobs, okay? What I would like to tell you is there is one tricky point here, and that's a situation that I think that most of you are really thinking about it and supporting companies. Hackers, they really don't follow GDPR. They really don't take care. And what is happening, we as individuals, companies, governments, we need to really have a very strong policy, procedure in place to really protect the data. That's the point. Why? Because once we have all these social media exposures, hackers, they are really looking for information that is spread everywhere. Most of the information we are sharing in our social medias, but most of the information that they are looking for can really bring impact they are going to find in our organizations. There is, on the last slide, one example. Just with one attack, probably you don't know about it, but we are on that environment. One attack on Friday impacted more than 1,000 companies in more than 11 countries. And I'm talking about some companies with 900 stores that were not able to open for some days already, just with one attack. And that's the power of the data protection that I'm talking about. Just to close my message, what I think that is relevant and important and is fully connected to you and with my world as well, the IT environment, is this powerful match and combination from the legal part and the IT world, because they are really connected, and we should have a really strong joint venture effort to protect the data that we have available for hackers. And that's my main suggestion for you. Thank you.
Thank you, Farley. Our next speaker is Selena Stan, who is from Romania, and she is a partner at FIDASmart. Selena?
Good morning, everyone. I would like to start by saying how a big pleasure it is to be here and a big honor at the same time, and to thank the team that organized, made all of this possible. You did a great job. Thank you. Today, I'm not going to talk about the implementation of the EU legislation within Romania. I would rather focus on a more hot topic, and that is the implementation of a memorandum that was signed by Romania and the United States in August 2019. So on the 20th of August 2019, after a visit to Washington, the President of Romania, Klaus Iohannis, announced that Romania and the United States entered into a memorandum regarding the deployment of 5G technology that was aimed to ensure that in this deployment of 5G software and hardware, the countries would ensure transparency and the rule of law. Now, the President specifically mentioned that the criteria were going to be put into a piece of legislation, and just a few weeks ago, the Romanian Parliament actually passed a law that transposes this memorandum signed in 2019. What the law says is that any manufacturer of 5G hardware and software that wants to put the product on the Romanian market has to obtain the approval of the Romanian Council of Defense, the Supreme Council of Defense. There are a few criteria mentioned in the law, and I will mention them as they are provided. First of all, the companies that apply for this must not be under the control of a foreign government. Second, the companies should have a transparent ownership. Third, the companies should not have been involved in any unethical corporate practices. And fourth, the companies must be subject to a justice system that ensures transparent corporate practices. In addition to these criteria, the Council of Defense also has to take into account all of the obligations that the Romanian state has assumed as a partner in various international organizations, as a member of the EU, and as a party to strategic bilateral conventions. So this is the legal framework that we will have to deal with as professionals. I will let you be the judge of whether the law provisions are detailed enough and are clear enough to ensure an objective decision, but I believe it will be our role to ensure that in this new legislative environment, the rule of law will prevail. Thank you for your attention.
Thank you, Selena. I will now give the floor to Eduardo Mayora, who is joining us from Guatemala, and he's the managing partner at Mayora and Mayora Abogados. Eduardo?
Thank you very much. Good morning. I appreciate the opportunity to share a few comments with you on these very let's say, avant-garde matters. As James has rightly pointed out, while there are some jurisdictions where the regulation of data privacy and cybersecurity are very advanced, there are some regions in the world where this has scarcely taken place. And Guatemala and in general Central America is one of those regions where there are very few regulations and where a few sections in the Free Access to Information Act and the ruling of the Constitutional Court on the basis of the primary fundamental right to privacy are the whole framework. And it seems to me that this poses a very serious threat to cybersecurity on a global scale because, of course, these jurisdictions where there are so few regulations can become a center or a hub for illicit operations regarding cybersecurity. As we all know, 5G and cybersecurity pose threats on several levels, including the specificity of data, including the speed of data transmission, and the frequency with which users would have to consent to sharing data and personal information. These challenges can probably be tackled by new technology based on 5G structures also, but definitely some global minimum standard, as has also been suggested by James, I think is entirely necessary before more problems of the kind that Selena has discussed come up. The regulation versus market solutions dilemma that is present in most occasions where new technologies are discovered and implemented is a very important dilemma this time as well. And it seems to me that probably market solutions in terms of cybersecurity will come forward before government regulation can really tackle the matter. But it seems that the minimum standards approach is a reasonable one, and hopefully the drive to achieve these minimum standards will come soon. Thank you very much.
Thank you, Eduardo. We now give the floor to Michal Jackowski, who is a partner of DSK Depa lawyers from Poland.
Thank you very
Michal?
much. Thank you, Diego and Teodora, for the invitation. This topic is extremely interesting for me because I'm, on one hand, a professor of constitutional law working on rule of law and privacy and data protection, but I'm also a practitioner working with IT companies, with new tech companies, And I'm also a governmental expert in Poland, working in working groups under 5G implementation. So I would like to share my experience, how tough, how hard it is to implement 5G toolbox in Poland. And it's both the implementation of technology itself and its institutional security. Starting from 5G strategy for Poland, the basic document that was prepared already in 2019, then it was published, consulted publicly, and until today it was not adopted by Polish government, and it's not up to date already, because it the strategy assumed the implementation of 5G network in one large agglomeration in Poland by 2020, which has not been performed. And it assumed uninterrupted access to 5G networks in all urban areas in Poland and major transport routes by 2025, which is highly endangered. All new frequencies provided for 5G network face problems. One requires a very difficult cooperation with Russia, Belarus, and Ukraine, which is really hard right now. The second one requires the auction for operators. The auction was started in 2019, then in 2020, due to COVID pandemic, was cancelled, and now awaits the act I will describe later on. And the third frequency requires releasing of 700 old permits and reservation, blocking the frequency until 2023. So look how complicated it is from technical point of view just to implement 5G. But there are also legal problems. Since 2020, there are works underway to amend the law on national cybersecurity system to implement 5G toolbox, which is EU recommendation, set of recommendations toward 5G. And the works are delayed for several reasons. Firstly, Polish authorities decided to use the implementation of 5G toolbox to seal the entire national cybersecurity system, significantly expanding the scope of the law beyond the toolbox 5G, but also decided to, for example, include elements of telecommunication law or law regulations on e-service providers. This raises significant opposition from all these subjects, which are strong in lobbying and delay the works. Second, there is an ongoing dispute who should control the national operator, who should control one of the frequencies, and there are several fractions of government trying to take over the control on this new company that should control 5G. And finally, there is a strong, significant discussion about the procedure for recognition of a high-risk supplier. Polish authorities indirectly acknowledge that the purpose of these regulations is to exclude supplies from China, primarily Huawei. This causes significant problems on the technological side, because approximately 60% of current 4G and LTE network is built on infrastructure from Huawei, and over 80% of infrastructure of electronic equipment commonly used in the networks is from China, Korea, and Taiwan. And the regulation do not apply only to 5G, but also to all elements of cybersecurity infrastructure. And it's not limited to critical or key resources. Theoretically, can require replacing of all hardware, software, and even ICT processes pertaining to cybersecurity systems that can be considered of high risk. As a funny fact, I must mention that also Wi-Fi routers may be included, and the regulation should work in such the way that upon issuance of a decision on high risk, the vendor is excluded from current purchases, and within 5 or 7 years, its current infrastructure must be withdrawn. But at the same time, a freezing orders can be issued upon which working immediately, upon which the infrastructure must be withdrawn. And public authorities within these freezing orders are not limited a lot. And what's most important, most crucial, new draft doesn't provide any compensation for such the limitation. Authorities compare it to limitation of business activity like business licensing and not expropriation. For me, as a constitutionalist, I expect claims based on European Convention on Human Rights or European law seeking compensation. You see how complicated this whole system of 5G implementation is. Thank you.
Thank you, Michal. Our next and final speaker is Elisa Figueredo. She is joining us from Brazil. Hi, Elisa. She's a partner at Abogados. Elisa?
Hello, good morning. First of all, thank you for the opportunity to be here. Unfortunately, not in person in Madrid, but thanks to technology, I'm able to participate on this panel. Well, considering our audience is made mainly by lawyers, I'll just call attention for two things that should be in your radar in case you or any of your clients are interested in doing business in Brazil regarding cybersecurity and privacy. First of all, here in Brazil, the disclosure of cyber attacks and any problem in cybersecurity is not mandatory. In some other countries, we know it's mandatory to disclose any problem on that issue. Although the companies are expected, and although it's expected and advisable for transparency, consumers, and governance reasons to disclose the attacks or any problem on cybersecurity, many companies here in Brazil does not disclose unless they have a reason to do that. That's what happened in a very important health company in Brazil in the end of June, that they had a hacker problem, and it came public just because all clients were not able to schedule their exams, or there were great delay on the results of their exams. So that's the only reason the company came into public to disclose the cyber attack. So although it's not, as I said, mandatory, it's really advisable to disclose such attacks. And by doing that, to rely on the legal team, because there are many different fronts that can be complained. It's the consumer complaints, the stakeholder doubts, there may be lawsuits and litigations, so you should rely on the legal team. So the second thing to be said, to be in your radar when you come to Brazil, it seems that I spoke to Farley Kothe before, but I didn't, is the GDPR problem. It's the personal data protection. The lack of obligation to disclose does not apply to personal data protection here in Brazil. In case of leaks of individual data, users data, it's mandatory to inform the National Data Protection Authority and also the individuals affected. Here in Brazil, the data protection law is in force. It's very similar to GDPR, but not exactly the same. So that's where comes what Farley said, the match between IT and law. So, and also, as Eduardo Mayora said, we are facing threats on cybersecurity, and as we all know, in 5G, it may increase vulnerability. So it's really important in our point of view to increase data protection concerns, and therefore to implement for those companies who have not implemented yet, and to improve for the companies who already have data protection policies. They may improve and really implement stronger policies and to make stronger actions to really protect data protections. That's it. Thank you very much.
Thank you very much, Elisa. We have time for a quick question, so here it goes for Farley. Which would you say are the major threats or vulnerabilities that you encounter as a company specialized in cybersecurity? What should we be aware of?
Well, one of the challenges. Okay. One of the challenges that I can see, it's the reason the companies are not really aware how exposed they are. Quite often, like I told you, we have been talking with we have a lot of customers, but we have like some companies that we are talking to, and most of the times, once you touch that topic about cyber, they would like to explore that topic, but they always normally share this information. We are really safe, we are ready, we are protected, and unfortunately, most of them, in a short period of time, they are going to face some problems, okay? And that is one of the reasons that I believe that here, all of you are supporting big organizations and the government. It's so important to push for this legislation and to make sure that all the companies, they need to follow some specific and strong rules, because there, in the companies, for example, the hackers are not going to find just data from the company. They are going to find data from the people also as well. So it's really important. And that is the main reason that I see issues nowadays, is the lack of knowledge, and the people are not really aware how dangerous can be one attack. They can really shoot down one entire organization. We have one customer that was shut down for 2 months. They were doing the internal cyber protection by themselves, and they needed to stop the line productions for almost 1 month. It's a big organization, so it's huge. It's really unbelievable, and it's something that we cannot skip. It's just here.
Thank you very much. That being said, I thank you all for your attention. I thank the speakers for their interventions, and I give the floor to Kim Quarles. Thank you.